The Subcommittee on Oversight and Investigations will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. This hearing is entitled Oversight of the SEC's Proposed Climate Disclosure Rule, A Future of Legal Hurdles. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the Chair for inclusion into the record. I now recognize myself for 5 minutes to give an opening statement. And I want to thank the witnesses for appearing before the subcommittee this morning, especially with some of the weather challenges, but I especially want to welcome my constituent, Mr. Bill Schultz, who is in from Mattawan, Michigan, and I'm really glad that you were able to make it and to be a part of this. As I indicated last year at our first hearing, oversight is a vital check on any administration's power and on those he or she choose to represent that administration. Today's hearing should not be confused with a debate on climate change, but rather whether the Securities and Exchange Commission has the legal authority to mandate climate disclosures from all companies, and that's, I believe, is going to be the effect. Nearly a century ago, Congress created the SEC to protect investors, maintain fair, orderly, and efficient markets, and to facilitate capital formation. These are timeless goals and objectives, and not to necessarily advance a particular agenda. As we approach the 2-year anniversary of the proposal of the SEC's climate disclosure rule and this subcommittee's year-long investigation into that rule, I think it's prudent to examine the facts. First, the SEC has wildly underestimated the costs the rule will impose on both public and private companies. Instead of conducting a thorough economic analysis, the already overwhelmed Division of Economic and Risk Analysis at the SEC relied on left-leaning environmental activist groups to justify its rulemaking. While the SEC asserts that the rule would cost current reporting companies roughly $10 billion a year, a recent study puts that number at closer to $25 billion a year, with little analysis on how proposed Scope 2 and Scope 3 requirements will impact small businesses who frankly can't afford a compliance department, a legal department. Furthermore, this past fall, the Fifth Circuit Federal Court of Appeals ruled against a separate SEC finalized proposal relating to shareholder or share repurchase disclosure. In that opinion, the court rightfully held that, quote, the SEC acted arbitrarily and capriciously in violation of the Administrative Procedure Act when it failed to respond to petitioners' comments and failed to conduct a proper cost-benefit analysis, close quote. Given the sheer volume, pace, and complexity of rules currently before the SEC, a 9.4% staff vacancy rate as of September 2023, and IG reports citing recruitment and retention challenges, one has to wonder how many finalized rules will ultimately be vacated by the courts. Which leads us to this question. In light of the Supreme Court's ruling of West Virginia versus EPA, does the SEC have congressional authorization to implement rules related to environmental or climate issues? In its ruling, the Supreme Court held that the EPA exceeded its statutory authority, relying on ambiguity as constituting an implicit delegation from Congress. Let's be clear. Congress has not delegated the authority to the SEC to require climate disclosures. The court's decision signals the SEC's authority to develop, finalize, and implement a climate disclosure rule is in jeopardy. And now, frankly, we're waiting on the Supreme Court, who took oral hearings yesterday on the Chevron doctrine. What is the boundaries? And this was about 40 years ago. There was the court ruling establishing that. So we are seeing a court in certainly re-examining that balance between an administration and Congress. So lastly, I want to close where I began, congressional oversight. I would be remiss if I didn't speak to the subcommittee's efforts to conduct oversight of the SEC's climate rule and get answers to many of the questions we hear about and we will be hearing about today in our testimony. Though the SEC has responded to the committee, one might be in awe of the imposing sounding 69,000 pages of documents that they've sent over. The devil is in the details. To date, the Commission has approved only 11,540 pages of responsive, non-public documents to be produced to the committee. That's 16% of the total documents produced. The SEC has flooded our subcommittee with unresponsive documents, including a copy of the rule itself, a copy of Chair Gensler's public testimony before our committee, which I might add I was sitting here for myself, press releases, and the entire public comment file, which of course is public. So given the lack of cooperation and the contents of the material turned over to the committee to date, I can only conclude that Chair Gensler is intentionally slow-walking our investigation. So I'll let those watching draw their own conclusions, but look at those details. So whether the final climate rule is finalized next week or next month, I think we can conclude that the chair has failed to not only convince his fellow commissioners, but the American people. And as we will hear today, he will likely not convince the court. I look forward to hearing from each one of our witnesses. And with that, I will be yielding to the gentleman from Texas, Mr. Green, the ranking member, for 4 minutes.
Thank you, Mr. Chairman. And I'd also like to thank you publicly for our gentle persons agreement, our handshake agreement that we arrived at on the floor yesterday. Thank you again. I also, Mr. Chairman, thank the witnesses, as you have, and I thank the staff for providing the intelligence that I will share today. Today's hearing is but another assault on helpful investor protection, climate change-related regulations. Friends, the science on climate change is clear, perspicuously so. It's not a question of whether it's going to happen, because it's already happening. For many public companies, extreme weather events or even slight changes in regional weather patterns can affect their operating performance. Recently, Coca-Cola was forced to close one of its bottling plants due to the overuse and extraction of groundwater. This shutdown resulted in an unexpected loss of profit and delayed manufacturing timelines. Some companies already include general disclosures about climate risk, but those disclosures are typically very vague, lack standardization, and do not provide investors with a good sense of the scale of the risk the company faces from climate change. The Securities and Exchange Commission, SEC, recently proposed rule on climate seeks to address this vagueness and lack of standardization, as well as provide clear guidance for publicly traded companies on climate-related disclosures. In a recent survey, more than 80% of U.S. investors indicated that companies need to more openly communicate the risks around climate-related factors, and 73% also said they are more likely to invest in a company that shares with investors its plans for effectively managing those factors. In response to increased investor demand for this type of information, in March of 2021, the SEC released a proposed rule to require public companies to make a variety of quantitative and qualitative disclosures regarding climate-related risks that are likely to have a material impact on their business. My colleagues from across the aisle are finding fault with the SEC's proposed rule, but offer no constructive solutions of their own. Those of you paying attention will very soon realize that this is a regular, recurrent, rhythmic part of the Republican playbook. Republicans opposed the Dodd-Frank financial crisis legislation, but offered no serious alternative legislation after the last financial crisis. Republicans continued to oppose the Consumer Financial Protection Bureau, but offered no alternative approach to protecting everyday consumers. Perhaps most notably, Republicans vehemently opposed Obamacare. The name may have had something to do with it, but the Republicans vehemently opposed the Affordable Care Act, but could provide no alternative even when in a position to repeal and replace it. Today's hearing is straight out of the Republican fictitious repeal and replace, the sky is falling playbook. Friends, the sky is not falling, and there is no need to repeal and replace. I yield back the balance of my time.
Gentleman yields back. With that, the handshake agreement that Mr. Green was referencing was how we were going to be handling our questioning, and I had decided that I will actually be deferring my 5-minute question period as well to the very end. So he will be going second to last. I will be the last for those questions. So I want to first introduce our panel. Today we welcome the testimony of Mr. Charles Crain. Mr. Crain is the Vice President of Domestic Policy at the National Association of Manufacturers. Mr. Lawrence Cunningham is Special Counsel at Meyer Brown. Mr. Bill Schultz, my constituent from the 4th District in Michigan, is the Vice President of Schultz Fruit Ridge Farms Incorporated, and on a personal note, I will tell you, makes one heck of a hard cider, especially the black currant flavored. So, Ranking Member, I'm going to work on getting us some samples. All right. That might help the operations of the committee. We'll see. And then Mr. Georgiev, Professor Georgiev is the Associate Professor of Law at Emory University. And we thank you for taking your time, and as I had said, your efforts of getting here with the weather and all those things. And without objection, your written statements will be made part of our permanent record. And Mr. Crain, you are now recognized for 5 minutes for your oral remarks.
Thank you, Mr. Chairman. Good morning to you and the Ranking Member and members of the Subcommittee. My name is Charles Crain, and I'm the Vice President of Domestic Policy at the National Association of Manufacturers. I appreciate the opportunity to testify today on behalf of the NAM's members and the 13 million people who make things in America. Manufacturing supports local communities and creates well-paying jobs. Manufacturing pioneers groundbreaking technologies, including the innovations necessary to combat climate change. And manufacturing powers economic growth here at home and supports American competitiveness on the world stage. But today, manufacturers are facing a regulatory onslaught. The total cost of federal regulations across the economy exceeds $3 trillion every year. Zeroing in on manufacturing, our industry faces $350 billion each year in regulatory costs. That's nearly a 30% increase from just a decade ago. And the average individual manufacturer pays more than $29,000 per employee per year to comply with federal regulations. And that figure rises to more than $50,000 for small manufacturers. $50,000 every employee every year. For a small company with just 20 employees, that's $1 million that's diverted every year from job creation or from R&D. The SEC's climate rule is at the center of this regulatory onslaught. The rule would impose tremendous costs on manufacturers of all sizes while overwhelming investors with immaterial information. And the SEC hasn't done the work to show that the rule's benefits outweigh its cost or that it's even within the SEC's legal authority. The rule's Scope 3 mandate exemplifies these flaws. Requiring larger companies to report their supply chain emissions is a significant burden, and it will fall directly on their small and privately held suppliers because it's their emissions that the SEC wants to know about. These small businesses will face an untenable choice between building brand new systems, buying expensive equipment, or potentially losing valuable customers. For the larger companies that are subject to the Scope 3 requirement, the SEC has admitted that it cannot fully and accurately quantify the cost of Scope 3 reporting. That's already a red flag for such a substantial requirement. But for the small businesses that are swept into these large companies' Scope 3 efforts, the SEC hasn't even tried. The SEC's proposal does not include any discussion of the Scope 3 cost that will fall on small and privately held businesses. The SEC has taken a similar approach to the climate rule's accounting requirements. The rule requires companies to conduct a convoluted tagging exercise to identify individual expenses that might be climate-related. Disclosure of those impacts would then live in the company's financial statements. Along with Scope 3, this is one of the most consequential and difficult portions of the rule. Yet the SEC has offered no tailoring, no delay, no flexibility at all for small businesses. Because these disclosures will be part of companies' financial statements, they'll be subject to external audit. But when the SEC set out to estimate the cost of that audit, it came up with an estimate of just $15,000. $15,000 to audit a brand new procedure that stretches down into individual invoices, that requires complicated judgment calls, and that might require a whole separate set of books for some companies. This underpinning the entire climate rule. And these flaws call into question the legality of the rule itself. Under the APA, rules can't just ignore a major aspect of a rulemaking problem, like the impact of Scope 3 on small businesses. They can't be based on faulty cost-benefit analysis. And perhaps most importantly, they can't exceed an agency's statutory authority. The SEC has only been authorized by Congress to require material disclosures to help investors make informed decisions, not to set climate policy. But the climate rule far exceeds what any reasonable investor would need to know about a company's climate-related risks. So we're left with a rule that delves into policy issues that are well outside the SEC's expertise or authority. Overall, the SEC says that the climate rule will cost more than $400,000 every year for small public companies. That's a huge resource diversion before even taking into account all the flaws in the SEC's cost analysis. Many small manufacturers will be forced to hire new staff or even expensive ESG consultants to keep up with this burden, all at the expense of manufacturing investment here in the United States. If the climate rule is finalized, small manufacturers and their workers will be the hardest hit. Manufacturers therefore greatly appreciate this subcommittee's efforts to rein in the SEC's regulatory overreach. Thank you for the opportunity to testify today, and I look forward to answering any questions.
Thank you, Mr. Crain. Your time has expired. And with that, Mr. Cunningham, you have 5 minutes.
Chair Huizenga, Ranking Member Green, members of the subcommittee, thank you for having me testify. I'm Lawrence Cunningham, a lawyer and scholar with 35 years of experience in corporate law, securities regulation, and investing. I'm special counsel at Mayor Brown and professor emeritus at George Washington University, though the points I make today are my own. I will explain why the SEC's proposal is outside of its power and harmful to investors. Congress authorized the EPA to protect the climate. It authorized the SEC to protect investors from fraud and deception in the securities markets. Your oversight is needed because the SEC proposal does not address ordinary American individual investors who need the SEC's protection to save for buying homes, for their kids' education, and for retirement. The proposal disregards evidence that individual investors mostly invest to save, not to influence climate policy. It disregards conflicts of interest between the large institutional asset managers and their beneficiaries, ordinary Americans whose preferences and goals differ. The proposal is unnecessary and harmful because existing SEC guidance, proven effective and flexible for more than a decade, already requires companies to disclose all climate risks that are material to their businesses. And yet the proposal would require irrelevant and burdensome disclosure outside the SEC's expertise and authority. The proposal would harm investors by forcing companies to disclose information about their suppliers, employees, and customers, which is useless for investors. Make companies disclose climate impact rather than climate risk, which investors do not need. It would impose millions of dollars of costs on companies, which will hurt investor value for no investor benefit and probably no climate benefit. It would compel the disclosure of information that is inherently speculative and uncertain, doing more to confuse than to inform. It would spur lawsuits over the adequacy of disclosure, which are costly even when baseless. All this would discourage companies from being public, which reduces investment opportunities for ordinary American investors. It would usurp state corporate law and company business judgment which undermines the interests and rights of investors. Your oversight is also needed because the proposal faces legal challenges under the major question doctrine for a lack of explicit congressional authorization for its sweeping, significant policy reach, under the First Amendment for compelling company speech on controversial matters, under the Administrative Procedure Act as it solves no problem within the SEC's mandate and fails to include a proper cost-benefit analysis. In sum, the proposal exceeds the SEC's congressional grant of authority, is an undemocratic power grab, and would divert resources from the SEC's statutory mission of protecting investors. I commend your oversight and urge you to examine how the proposal would hurt millions of individual American investors that Congress created the SEC to protect. I welcome your questions.
Thank you, Professor Cunningham. Appreciate that. With that, Mr. Schultz, you have 5 minutes.
Chairman Huizenga, Ranking Member Green, and members of the subcommittee, thank you for your invitation to speak today. My name is Bill Schultz, and it is my honor as Vice President of Schultz Fruit Ridge Farms Incorporated to come before you today to speak about the SEC's Scope 3 emissions reporting requirements, which could negatively impact our multi-generational family business. I represent the third generation of my family to grow fruit in Southwest Michigan. I farm in partnership with my parents and my 3 siblings. We produce a wide variety of crops, including apples, peaches, grapes, and cherries. Growing fruits and vegetables on 300 acres for our customers and community is a very fulfilling experience, and I would consider it a privilege. I have the opportunity to interact with roughly 10,000 consumers annually. I spend my Saturday mornings at our local farmers market, engaging with our customers and educating them on the happenings out at the farm. We get involved with our local schools to get fresh apples into the lunch program. Further, every season, we make an effort to donate some of our farm's bounty to local food pantries. Meeting so many families and sharing the story of agriculture as they visit our farm market, and our restaurant each season is priceless. We are our community's farm in so many ways, and I fear that the SEC's rule could put our industry at risk. This rule would require extensive reporting by public companies on their Scope 3 emissions, which are the result of activities not owned or controlled by the company, but are in its supply chain. And I expect most family farms in America will be touched by this proposal because these farms' products end up in the value chains of public companies. Whether it's a grocery store, a fertilizer company, a packer, or any of the other public companies we do business with, the farms in their supply chain will be impacted by Scope 3. Our industry's focus is on growing the food, fuel, and fiber that this country needs, and being subjected to regulations intended for Wall Street does not advance that work. While large multinational companies have consultants or attorneys dedicated to handling SEC compliance, farms like ours do not. Complying with this rule would be significantly more difficult for our farm. The cost would be much higher. Our farm has no experience with the SEC, and we have a hard enough time competing in this current environment. This rule pushes towards more consolidation and gives our competitors one more advantage over family farms like ours. Investing in environmental stewardship is important to us because we want to take care of the land that we live on and pass our family farm on to the next generation. We have adopted conservation practices that include planting cover crops to build soil fertility. We've installed trickle irrigation systems to minimize water use, and we've planted living row middles in our orchards to reduce the need to mow. I am passionate about planting and have personally set thousands of bushes trees, and vines with my own 2 hands. We plan and we plant for the future. For over 70 years, my family has persevered through all types of adversity, from weather extremes to challenging markets, from labor struggles to maintaining profitability. A life in agriculture is not for the faint of heart. Unfortunately, we now face a new and crushing regulation to this list of our challenges. On top of the resources needed to collect this information, growing an apple is not like making a widget. Farming presents variables that are rarely present in other businesses. An apple tree, for example, takes many years to start producing fruit that can be eaten. Weather events or plant pests and diseases create hurdles year to year that would deeply complicate the reporting process, and it is clear that the SEC did not account for these complexities and nuances of farms when writing this rule. So in conclusion, consumers are already facing high costs at the grocery store, and this rule will only worsen this problem. Small and medium-sized farms are the lifeblood of our industry and the pillars of our rural communities. Thank you for the opportunity to share my perspective today.
Thank you, Mr. Schultz. With that, Professor Georgiev, you have 5 minutes.
Chairman Huizenga, Ranking Member Green, members of the subcommittee, thank you for inviting me today to testify at this important hearing. My name is George Georgiev, and I'm a law professor at Emory University, where I teach and write about corporate governance and securities regulation. I have focused on the SEC's disclosure rulemaking for 15 years, first as a practicing lawyer advising companies on securities law compliance, and subsequently as a legal scholar. My remarks here today are solely in my capacity as a legal scholar, and I'm not testifying on behalf of any group or entity. I think this hearing is very important. I think the SEC's climate disclosure rulemaking efforts are much needed. And I think because they're much needed, because they have been visible, and because securities law is quite complex, there have been actually quite a few misunderstandings about what the SEC is trying to do, what's in the actual rule, and how the legal analysis should unfold. So let me spend a few minutes talking about some of those misunderstandings. And those are actually objective and factual. They are not, for the most part, matters of opinion or dispute. So first, I want to emphasize that the SEC's climate-related disclosure proposal is about providing information to investors for purposes of market efficiency, capital formation, and investor protection. It is not about regulating climate change. It does not seek to effectuate substantive regulation of climate. And moreover, the SEC cannot do that even if it wanted to. It's merely about information. Second, it's true that because of the importance of the subject, it has attracted attention from both core mainstream investor constituencies as well as non-investor constituencies. But the mere fact that non-investor constituencies are interested in the rule should not mean that the rule is suspect or that it should not be adopted. The SEC has focused on the informational needs of investors, and this is what is driving the analysis, the content of the rule, and the SEC's efforts. Third, investor support for the SEC's rulemaking is near universal, close to 95%. Moreover, many US companies in different geographies, of different sizes, in different industries, have actually come out in support of the rule because they recognize that they need this information in order to manage their business, and they need regulatory guidance, which is very important. The current framework relies primarily on voluntary disclosures, and voluntary disclosures provide flexibility, that's true, but they also entail a high degree of legal risk, compliance risk, and also they're very time-consuming and costly. So legal certainty is what companies want, and this is what the SEC has sought to provide. Let's talk a little bit about investor demand. Investor demand is real, it is important, but the SEC's proposal does not depend on an assessment of the intensity of investor demand or even on investors' fluctuating interest in sustainable funds. Even if sustainability-related funds, sustainability-labeled funds, were to be abolished somehow today, there would still be a very strong case for the SEC to promulgate climate-related disclosure rules because they go to the risks and opportunities of companies, and how companies should be assessed by investors in their decision-making. The next point is about the difference between retail investors, real investors, individual investors, and large institutional investors. And I want to point out that climate-related disclosure helps with market efficiency, just like all disclosure does, helps with price accuracy, helps with price discovery. And so it will help both retail investors and large investors. Even if retail investors don't care at all about climate, they care very much about the fact that they should be buying and selling securities at accurate prices. And if securities are mispriced, that's a very serious problem for the capital markets. Next, the proposed SEC requirement on greenhouse gas emissions Scope 1, Scope 2, and Scope 3 is intended to give investors an understanding of the issuer's transition risk. And this is a well-established and uncontested source of business risk that will remain present regardless of what the SEC does. These emissions disclosures do not and cannot be reflective of a double materiality approach. They do not seek disclosure of the firm's impact on the environment. Finally, the SEC has sought to design a workable rule by incorporating liability safe harbors, delaying the effectiveness of certain provisions, and endorsing the use of estimates. And by all accounts, the SEC is actively working and taking those considerations into account. Thank you for your time, and I look forward to your questions.
Thank you. Appreciate that. And with that, we are going to start with the gentleman from Texas, Mr. Sessions. You have 5 minutes for your questions.
Chairman, thank you very much. Sir, thank you for your feedback to us. Does the SEC ever use filings that people make to go back and fine them for things that they did not comply with in their filing? Yes, sir.
Yes, it does.
So it does. So it takes this, what is supposed to be that you described as important data, information that was shared for market accuracy and to do, and then they do something with it. They come back if somebody got something wrong and they fine them. It's a weapon, sir. And this is why these darn Republicans today are saying there's so much that's unknown. There's so much that really can't be connected, and yet you've got to put it into a filing. Thank you very much. Mr. Schultz, I'm a 28-year member of the Texas Farm Bureau. I recognize that your idea of agriculture and mine is there to help the consumer and feed the world. And I want to congratulate you on your fine young member of Congress that you have, because he's doing a heck of a job up here. But in that, I want to see if you could go through and give me some idea about having to comply with these regulations and yet look at the SEC, the things that you have to do for across the board to give a good product out. And now your family-owned business is going to have to comply with this. Please go into a little bit more detail, because Texas has many people who are small business owners just like you. What would happen to you and what might happen to them?
Well, thank you for the question, Congressman Sessions. That is a great question. So it's a department that we have not dealt with in the past. SEC, doesn't usually get involved with farm operations, if you will. And the concept as a whole will send ripples across the industry. It adds a layer of management that costs to initiate, but it doesn't necessarily add value to the product that we produce. So farmers tend to be, as you know, they tend to be price takers. We take what we can get. We don't get to set our price. So, and that's part of the reason that this, we're hearing today, it's like, what is the effect? And it's a broader program than I think what a lot of people might actually realize.
So you're a legal company, and the SEC is going to reach their hand down and apply this to you. They're going to apply their rules and regulations on you, and you had never even come into contact with them. And now they're going to reach in and grab you. Is that correct?
Well, the potential for them to, have the data that they believe to be accurate could be used, against the company that they're, monitoring, possibly, I would imagine.
And would look at your response. or lack of response because you may not have known you had to file.
Yes, it would be a very complicated thing to effectively manage. Every farm is unique. It's like, I say it's like the color of the rainbow. They're all farmers, they're different shapes, colors, and sizes. They produce different crops, and you can't throw them all into one bucket. It's just not, there's a lot of variability. Things vary like production from year to year. No fault of our own. Sometimes we can produce half as much. It costs almost as much from a capital side of things. We still have to spray and water our crops, but if the weather took half of our yield, we have to have the same inputs. And so that would look bad on paper, no fault of our own.
Well, these things happen, and I do recognize that there is climate change. I'm a MAGA Republican, and I recognize there is climate change. But in that process of the SEC coming down and putting rules and regulations, it is there, in my opinion, also to punish people, and that is the threat. But the cost that was spoken about from National Association of Manufacturing is staggering on companies to guess, in my opinion, of what their answer would be. And that is why we wrote a letter not only to Mr. Gensler from myself, but also about 50 members of Congress that was dated September 26th, where we agree with you. And so I just want you to know that as you provide feedback to us today, we've heard you and we appreciate what you're doing. Thank you very much, Mr. Chairman. I yield back my time.
Gentleman yields back. And with that, the gentlewoman from Texas, Ms. Garcia, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for being here today. And I, too, thank you for braving the cold, and hopefully you'll get out of town before the next one hits us tomorrow morning. It is no secret that the SEC is leading the way in climate-related disclosures. This disclosures not only promote better transparency to inform consumers and investors, but also help the industry track their environmental, social, and corporate governance goals. Many U.S. investors are requesting companies to openly disclose their climate risks. Some companies are already including general disclosures, but it is not nearly enough. These disclosures are typically very vague and don't provide investors with enough information to make a climate-conscious and informed decision as they construct a portfolio and analyze risk. Mr. Georgievi, could you discuss why so many investors are pushing for more accurate, reliable climate-related disclosures and how a company's climate risk can lead into a financial risk for investors?
Thank you for this question. I think the reason why investors are so interested and so adamant about having companies provide accurate, comparable, and decision-useful climate-related disclosure is because investment analysis is difficult, investment analysis is complex, and it is also by its very nature comparative. So investors need to be able to compare different companies, and unless they have comparable information, accurate information, they cannot do so. And this is, by the way, the entire reason why we have financial accounting, which took decades to develop. And now, with this new source of risk and new source of impact, investors similarly are demanding comparability. Let me just add that having an adequate SEC disclosure regime, which is completely in line with what the SEC has been doing for 9 decades, actually helps investors save on their research costs. Because otherwise, it's not like investors are not going to look to this information. Rather, they would rely on estimates, they would send companies surveys, and it will be a much more burdensome and time-consuming process for all involved. So this really is actually a cost-saving initiative in the aggregate. And I think it should be welcomed.
Right. I'm completely baffled by this whole notion from some people who suggest that the SEC does not have sufficient legal authority to provide for this disclosure requirements. Like you, I'm a lawyer. In fact, I'm also a former judge and also former city controller in Houston, where I handle an investment portfolio where we had to make disclosures in some of our bond offerings. And it just baffles me that someone suggests that the SEC wouldn't have authority, because quite frankly, they've got lots of lawyers over there that even for the littlest thing, they raise the red flag if there's no legal authority for them to do something. So in your view, sir, I know that you've done some research on this topic. I know that you authored a comment letter to the SEC on this topic. Do you think that there is sufficient legal authority, or do you think there's any credence at all to this whole notion that there isn't?
I absolutely believe that the SEC has sufficient authority, and this is evident through multiple indicators. The actual plain text of the underlying statutes, which date back to the 1930s, the legislative history of the statutes, judicial analysis of the statutes, and then SEC rulemaking practice, as well as the fact that Congress has had multiple opportunities to restrict the SEC from promulgating disclosure rules, and it has not done so. If anything, Congress has only encouraged the SEC to continue with a disclosure regime, which is a hallmark of successful capital markets, and one of the key features why the U.S. capital markets are the best in the world. So as early as the 1930s, Congress put in place the underlying statutes. And let me just quote former Chairman Jay Clayton, who in 2018 said that the SEC's disclosure regime is powerful, far-reaching, dynamic, and ever-evolving, and that it is a key responsibility for the SEC to keep updating the disclosure regime to ensure that there is an adequate mix of information for investors to make investment decisions. And during that Republican-led commission, the SEC adopted new disclosure rules on human capital management, for example. They were supported by the Republican-appointed commissioners, and this was based on extensive evidence that this is the type of information that investors would like to see, that the risks of the time are different, and those disclosures have been welcomed, and they have not been challenged at all.
Thank you, and I see I've got only 2 seconds, so again, thank you all for being here today.
Gentlelady's time has expired, and with that, the gentlewoman from Missouri, Mrs. Wagner, who is the chair of our Capital Markets Subcommittee, has 5 minutes.
Yes, thank you, Mr. Chairman, and I'll get right to it. Mr. Crain, in December, the Fifth Circuit vacated the SEC's share repurchase disclosure rule, which would have created new disclosure requirements for companies engaging in stock buybacks. The court held that the SEC acted arbitrarily and capriciously, loved that word, and it ignored petitioners' comments and failed to conduct a proper cost-benefit analysis. I could have written it myself. Does the SEC's proposed rule on climate risk disclosures have the same deficiencies, sir, as a stock buyback rule?
Thank you for that question, Congresswoman, and I think you're exactly right. There are some real parallels between what the SEC did with the buybacks rule and what the Fifth Circuit said in that case and what we're seeing with the climate rule. As you indicated, a key failing that the Fifth Circuit identified was the SEC's lack of a robust cost-benefit analysis, and that's exactly what we're seeing with the climate rule, a failure to consider key aspects of the impact that it will have on businesses, especially small and private businesses who are going to get pulled into this Scope 3 mandate. Those costs are not estimated, not reflected in the rule at all. So I think there are real failings in what the SEC has done.
There are failures in all of them. There's some 50 to 60 rules that have nothing but, I call them cut and paste cost-benefit analysis. They take them from one small little paragraph, one rule, cut, paste to the next, to the next, to the next. I'm glad the Fifth Circuit did that. In November 2023, the court gave the SEC an opportunity to correct the buyback rule's defects. The court later found that the SEC received comments that would have allowed the agency to quantify the rule's economic effect prior to issuing the final rule. It led them to try and fix their problems. But it failed, the SEC did, to use those comments to conduct a cost-benefit analysis. Mr. Cunningham, does this indicate deeper problems in the SEC's rulemaking process?
Thank you, Congresswoman. It may well. Certainly that case was not a shining moment for the agency. I would hope and assume that it's taking the lessons from that ruling. And
they keep losing in court, sir.
and ideally, they would try to apply your question to this proposal and try to reevaluate it.
Do you believe that the other 50-plus rules being proposed and finalized by Chair Gensler, Mr. Cunningham, Chair Gensler's SEC will run into similar issues with the court? And if so, could you list a few for us, sir?
I think the volume is very difficult for any agency to produce and to faithfully comply with the Administrative Procedure Act's very specific requirements around cost-benefit analysis, rational basis, and so on.
APA is not being followed. Mr. Cunningham, in the stock buyback case, the court said the SEC not only failed to validate the rule's costs and benefits, but failed to identify the problem they were trying to correct. Key here, what duty does an agency have to substantiate the problem they are intending to address in a rule?
A very specific duty. It has to generate a substantial basis for its rule, and it has to explain in a rational way what it's trying to accomplish. It also has to solicit public comment, and so it needs to articulate some problem, some benefit. And the agency's own policies require it to do that as well.
Well, the court noted that the simple finding of a benefit, and I thought this was very, very informative, the simple finding of a benefit is not enough to substantiate the need for a new rule on its own.
Right.
Why does the court require agencies to substantiate the problem the rule is intended to fix?
Well, without substantiation of the problem, you risk being accused, maybe rightly, of being arbitrary and capricious, the word you love so much.
Just like
And so,
the court said.
Yeah, that's what an agency is required to do. Just articulate a rational basis that the public can participate in commenting on, and that will entail identifying a problem and identifying benefits from the solution.
Why should Congress and the American people be concerned if an agency, like the SEC, is allowed to propose a rule simply on the basis that it would provide a benefit to the public rather than working to fix an actual issue that is a current problem in the market?
Agencies, look, Congress creates the agencies and endows them with some powers, but it cannot delegate legislative powers to those agencies. So the agencies need to be responsive to Congress and to the judicial branch as well. And so there's a balance among the executive, Congress, and judiciary, and without adhering to the APA, it upsets that balance. And so the American people would be right to be concerned about upsetting the democratic process.
My time has expired, and I appreciate the chair's understanding, and I yield back.
We've been amazingly disciplined. That's the first time I've had to tap the gavel at all today. So with both the witnesses turning in extra time and the members. So with that, the ranking member of our committee, Ms. Waters from California, is recognized for 5 minutes.
Thank you very much. Georgie, Vive, opponents of the climate proposal have long argued that the SEC lacks the legal means to require companies disclose their emissions data and related risk. However, in a comment paper you submitted on the proposal, you go into great depth about the pre-existing authority of the Commission. The Commission has, you said, they have the authority to promulgate such disclosure requirements, particularly in the area of environmental-related matters. Could you briefly summarize how the SEC has legal authority to require that public companies disclose their climate risk and emissions metrics?
Yes, the SEC's legal authority stems back to the original statutes in the 1930s, and this is an authority that the SEC has exercised time and time again for 9 decades. So it's not something that they just discovered today or yesterday and decided to regulate. They have actually been continually engaged in the iterative improvement of the disclosure framework. This is their mission, and this is what they've been very good at doing. Importantly, they've both expanded the disclosure framework and they've also scaled it back as the needs of the time and as markets and technology require. So it's not just an ongoing process of expansion, it's actually a process of calibration and tailoring, and the SEC has been very successful at doing that. Let me quote from the DC Circuit, which looked into this very question, and they found that rather than casting disclosure rules in stone, Congress opted to rely on the discretion and expertise of the SEC for a determination of what types of disclosure would be desirable. The DC Circuit also said the Commission has been vested by Congress with broad discretionary powers to promulgate or not promulgate rules requiring disclosure of information beyond that specifically specified in the statute. The statute specifies about 32 categories of information and tells the SEC, look at that information and calibrate it on an ongoing basis. And the SEC has done just that.
So would you conclude that perhaps there needs to be legislation to clear up the question so that the SEC feels more comfortable in its authority?
Not really, because this is not a question that should be contested or is contested. The courts have spoken, the SEC has exercised this authority, and by not prohibiting the SEC from promulgating disclosure rules, Congress has acquiesced to the SEC's actions. So additional legislation could always be helpful, but it's not necessary. And there are many other things that are before Congress that are much more contested and more important.
Thank you. Mr. Cunningham, on your law firm Mayor Brown's website, it states, and I quote, environmental, social, and governance, that is ESG, considerations are increasingly high priorities for global businesses. Mayor Brown has a strong track record in helping clients around the world address ESG issues. Recognizing the importance of ESG principles to its clients, Mayor Brown also has a core commitment to engaging in responsible business practices in its day-to-day operations, including with respect to ESG. ESG policies and best practices are not only moral imperatives, but also commercial necessities, quote unquote. It sounds like Mayor Brown and its clients think ESG considerations are material to investors. Do you disagree with your firm, or is your firm engaged in greenwashing also?
I'm very proud of the policy that you articulated, although I have nothing to do with it. I'm not a member of the firm. I'm special counsel of the firm, so I'm an employee. But I think that's a impressive articulation of a important firm policy, and I practice in the area, and so I'm certainly very keenly aware of the space. And again, companies take this seriously, and they have been taking it seriously for a long time. The SEC's existing rules require exactly the disclosures that you were just talking about, and has the authority to do that. This rule goes far beyond the sort of legitimate scope of ESG policy that you've articulated.
Did you know this was on the website?
Sorry?
Did you know that this statement was on the website?
Yeah, I think I've seen it, yes.
You've seen it before.
I think so.
You agree with it?
Yes, I said I'm proud of it. But
All right.
again, I don't have anything to do with it because I'm just an employee of
You're proud, but have nothing to do with it. You're just a lawyer.
well, partners at the law firm would have a role in articulating the firm's philosophy, and I'm not a part of it.
Gentlelady's time has expired.
Okay, sounds a little strange. I yield back the balance of my time.
Gentlelady's time has expired. With that, the gentleman from Tennessee, Mr. Rose, who is the vice chair of our Oversight and Investigation Subcommittee, is recognized for 5 minutes.
Thank you, Chairman Huizenga, and thank you to our witnesses for taking time to be with us today. This is an important hearing, I believe, and since the notice of the proposed rulemaking in April of 2022, I have been extremely concerned by the implications of the SEC's proposed climate disclosure rule. Just this week, I received a letter from the American Securities Association highlighting the damaging impacts that the finalization of this rule would have on our economy. Mr. Chairman, I ask for unanimous consent to enter the following letter entitled "The Consequences and Negative Impacts of the U.S. Securities and Exchange Commission's Climate-Related Proposal" from the American Securities Association into the record.
Without objection.
Thank you. As the owner of a family farm myself, I am most concerned by how this rule would impact the agricultural industry. In May of 2022, I led a bipartisan letter to Chairman Gensler that 117 of my colleagues signed, a bipartisan letter highlighting the impacts that this proposed rule would have on farmers and the agriculture industry, particularly the Scope 3 disclosures that are in the rule. The fact that Chairman Gensler and the SEC are still pursuing this rulemaking 20 months later only further indicates, in my view, the lack of understanding that unelected Washington bureaucrats have for the work that farmers do. Mr. Schultz, as a member of Michigan Farm Bureau and the owner and operator of your family farm, I am grateful that you are here today to represent the industry that is, in my view, the backbone of America. Can you give us an idea of how big your family farm is, beyond what you said in your opening remarks, and how many people work there?
Thank you for the question, Congressman. I can tell you that on this time of year, we have about 10 individuals working on our farm, half family and half regular staff, and then that might grow to approximately 30 during the harvest season. Our office staff consists of my mother, my sister, and myself when I can pitch in. So we don't have a separate department for that.
I understand, and that's frankly typical of American farms across the country. Mr. Schultz, how would a one-size-fits-all approach to disclosure requirements, like the one proposed by the SEC, frankly, impact family farms like yours and others in your community?
Yeah, so I understand like the backbone of this rule was written for investors in Wall Street, but we live on County Road 652. So that's a little bit different. That, builds the backbone of our community, if you will, small businesses, small farms. And so I think that the potential for this to kind of get carried away from its initial intention exists.
And so if the Scope 3 requirements that are in the proposed rule, as we've seen so far, if they went into effect, and let's imagine that you had to hire somebody to work with you and your mom and your sister in that office that was an expert in these areas to help you comply, and let's say that cost $50,000, well, you would just increase the price of cherries to recoup that $50,000, right? That's how you'd approach this.
Unfortunately, that's not how it works in agriculture. So besides what we sell direct to our customers at our market, we have no idea what we're going to get paid oftentimes for what we deliver. Our cherry crop last year was picked in July, processed. It's in a freezer plant somewhere, and they will give us a final price in March, and we take what we get.
Right. You're price takers, not price setters.
That's correct.
Another aspect of the proposed climate disclosure rule that worries me is the disregard for materiality. As an investor myself, I know that materiality has been, and a lawyer as well, has been the bedrock standard of securities law in this country to maintain fair and transparent markets. However, it also ensures that we are not being overly burdensome on companies and hurting market competitiveness. Mr. Crain, what would be the potential consequences if the SEC required the disclosure of non-material climate information?
Absolutely. Thank you, Congressman. As you just articulated, immaterial disclosures by definition are pure cost drivers, right? A material disclosure is something that a reasonable investor would need to know to understand a business. An immaterial disclosure means that that investor doesn't need that information. So the only thing that comes from that is the cost on the business. And so we run a real risk as the amount of immaterial disclosures increase, corresponding cost on businesses continues to increase without any real investor benefit.
And to be absolutely clear, public companies are already required to report every piece of material information, correct?
That's exactly correct.
Thank you. I see my time has expired. I yield back.
Gentleman yields back. With that, gentlewoman from Michigan, Ms. Tlaib, is recognized for 5 minutes.
Thank you, Mr. Chair. The majority's memo for today's hearing mentioned concerns about the SEC's statutory, authority. I know the SEC's disclosure regime can be traced back, I think, more than 90, or like roughly maybe 90 years, to Schedule A of Section 7 of the Securities Act of 1933. With Schedule A, Congress delegated to SEC the power to mandate disclosures of 32 categories of information and, quote, such other information as the Commission may by rules or regulations require as being necessary in the public interest or the protection of the investors, end quote. So, Mr. Georgiev, has Schedule A of the Securities Act of 1933 ever been amended or repealed by Congress?
No, it has not.
Now, the SEC has continuously revised and updated its disclosure requirements, as we all know. The Commission has established disclosure rules on everything from executive compensation to asset-backed securities to human capital management. The SEC has also required environmental disclosures going back to Nixon administration. Is that correct?
That is correct.
So, Mr. Georgia, can you discuss the history and breadth of the issues about which the NEC has required disclosures, including environmental disclosures?
Yes, absolutely. The SEC's guiding philosophy is that it should provide an information-generating framework to ensure comparable decision-useful information for investors. And so the SEC looks at markets, looks at economic developments, and calibrates the existing disclosure framework for the conditions of the time. And that's why, even though Schedule A has not been repealed, the SEC has expanded and narrowed down certain disclosure requirements, basically engaging in ongoing tailoring, iterative modernization, you can call it different things.
I mean, Professor, I think in 1979, the DC Circuit Court of Appeals stated that, quote, the commission has been vested by Congress with broad discretionary powers to promulgate or not to promulgate rules requiring disclosure of information beyond specifically required by statute.
That's absolutely correct, because Congress realized that it cannot monitor on a real and current basis what is going on in the markets. Financial markets are extremely important. Capital formation is extremely important. Investor protection is extremely important. And that's why we need an expert agency to do that.
And Professor, you know, it's important. I just want my colleagues to understand. Over the course of 9 decades of ongoing rulemaking, has any court invalidated an SEC rule for exceeding its disclosure authority?
No court has invalidated the SEC's rulemaking for exceeding the disclosure authority, and I don't think a court should do so with this rule as well.
Again, it's the process out there, and again, we're talking about last time, I think in 1979 and so forth, but I want to switch gears and touch on the benefits and costs of the rule. First of all, the U.S. companies should not be allowed to obscure their exposure to climate crisis risks, threatening the investment of retirees. I mean, these are our residents, our constituents, workers who need standardized and reliable information. But what about the compliance costs that everybody keeps on? Both I think California, European Union have adopted mandatory climate-related disclosure requirements, which are likely to be more extensive than even the requirements of SEC's final rule. So, Mr. Georgia, since thousands of U.S. companies will have to comply with California and EU disclosure requirements anyways, right? What impact will this have on net compliance costs?
Let me just step back and say that the SEC by statute is not required to compare costs and benefits and conclude that there is a net benefit. So Congress has not determined that this is something that the SEC needs to do, because cost-benefit analysis of financial regulation is very difficult, and courts have even said that an agency is not required to measure the immeasurable. It should not engage in speculation. And so I think that is very important to understand about the proper role of cost-benefit analysis. Now, it is exactly the case that both California and the EU have adopted mandatory disclosure requirements, very closely resembling those of the SEC, and actually in the case of the EU going much further. And so 3,200 US companies are expected to be captured by the EU's sustainability reporting requirements. That's a lot of companies, and they will need to comply with those disclosure requirements. And so the added cost, the marginal cost of SEC compliance is likely to be zero or very minimal. And in fact, standardization, harmonization, coordination can actually help.
Yeah, well, just for my colleagues, like, let's not distract from legal authority or compliance cost. Like, we're distracting the public. It's really important for us to protect our constituents, and this is one way we can do that. Thank you.
Gentlelady's time has expired. The gentleman from Oklahoma, Mr. Lucas, our chair of the Science Committee and former chair of the Agriculture Committee, is recognized for 5 minutes.
Thank you, Mr. Chairman, and I'm particularly pleased that you invited a real farmer to be with us today. That's always a bit of fresh relief in this place.
I will note we've got a couple of real farmers on the committee as well, so but it's always good to have someone else in the audience.
Absolutely, but we have a day job. His day job is on the farm every day. Mr. Schultz, turning to you for just a moment. You've discussed a number of the issues that involve the impact of the SEC's proposed regulation on you. Once again, remind us, ultimately, I suspect this will bring cost onto you and every other farmer and rancher in the United States. I am very concerned about how you deal with that. So tell us for just a moment, in the nature of your family business, which is really kind of typical in many ways of small farms and ranches in the United States, when you're impacted by the additional cost, potentially you'll have to have more staff. when it comes time to fill out the forms that I suspect the people that you sell your product to, not just retail consumers, but if you sell to an entity that then uses that in a fruit or a jam process or in some other prepared food process, they will turn back to you to fill out things in order for them to cover their backside. The reality. You
Yeah,
can't just
so-
raise prices.
Yeah, from a down-to-earth point of view, if you will, yeah, compliance, everything has a cost. There's a cause and effect. And so there will be additional management, if you will, to this compliance. And so as an example, we are Welch growers. We raise grapes, Concord grapes for Welch's grape juice. And we already participate. They have a sustainability survey where they make sure that their company, our company, because we're a grower-owned co-op, scores in a sustainable way. That we can keep on doing what we've been doing for decades and in a way that cares for our land. That being said, like some of their bigger customers are publicly traded companies. You know, might be a Walmart or a Costco or a grocery store of some sort. You know, they're gonna pedal back and they're gonna look at their suppliers and they're gonna say, hey, you know, what does that actually look like? And they're gonna screw down onto that. So we're doing a lot of these things naturally without additional.
So if you can't move the cost downstream, then you have to absorb the cost within your organization, which limits your ability to expand or grow or to enhance the quality of life of your family and your employees. It's kind of a catch-22, isn't it, from your perspective as a small business person?
Correct, yes. I mean, it takes, understand, it takes, money to make money, but we naturally are progressing. We upgrade our equipment so that it is more efficient. When we have a good year, when we have good margins.
Let me raise an additional point for the panel. In place of any cost-benefit analysis, the SEC instead relies on international standards developed outside the Commission, such as the Financial Stability Board's Task Force on Climate-Related Financial Disclosures, the TCFD. The task force's report alleges there is currently a misallocation of capital towards carbon-intensive industries, and that these disclosures will help correct that. It appears that the SEC is pushing forward international standards with the self-described goal of redirecting the allocation of capital towards preferred activities. Mr. Cunningham, can you speak to the SEC's difference to international standard setters and what is the risk of us using these as jurisdiction over climate-related disclosure rule?
Yes, thank you, sir. There is no evidence that U.S. securities markets are mispricing stock that leads to capital misallocation. I can't speak about the markets in the rest of the world. They're probably not as efficient as ours. And those international standard setters are focused not on U.S. markets, but on global markets. So it would concern me if the SEC decided to follow international standard setters rather than focus on our own markets, which might be quite different.
And I would note for the record, it's worth noting that the chair of the Financial Stability Board's task force is an individual that has spent hundreds of millions of dollars on campaigns to shut down American energy and chemical businesses through initiatives like Beyond Coal, Beyond Carbon, Beyond Petrochemicals. The report from the TCFD is given legitimacy when the SEC replicates it for its own climate rulemaking. However, an SEC rule is an entirely different burden than a voluntary disclosure network, even when written by activists. Mr. Crain, can you discuss the practical differences between these voluntary disclosure frameworks and the SEC's proposed rule?
Absolutely, and I'll be brief because I know your time is short. Many companies are participating in the TCFD framework in a way that makes sense for them and their business. The SEC would impose a compliance burden that is a government mandate. It's really an apples and oranges comparison.
Thank you, and thank you, Mr. Chairman.
Gentleman's time has expired. With that, the gentleman from California, Mr. Vargas, is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I appreciate this meeting very much, this hearing, and thank the ranking member. You did say, though, however, Mr. Chairman, that this was an oversight and made a claim that the hard cider from Schultz Fruit Ridge Farms is very good, and I hope that we get a chance to do oversight on that personally.
So moved.
And it is an honor to have you here, sir. I agree with what the SEC is attempting to do here. I think that that's no secret. I've always have, and I think that it's certainly within their jurisdiction. We've talked a lot about the courts today, and it's very interesting. You get old enough, and I guess been around long enough, you find out that sides change. It used to be that my Republican colleagues used to look to the courts and say they're a bunch of activist judges. We need to change them. We need it differently. Then they did. They did change the judges. Now you have more conservatives. Now they look to the courts. They say, well, the courts said this. You know, and I guess I look at it and I remember my law school days, one of my professors, Roberto Unger, who said that the legal outcome in a dispute really depends on the particular legal notable. And the particular legal notable is potentially the judge, you know, whether he's conservative or whether she's liberal, or the bad attorney or the good attorney. It depends on what you do, because you get people to do the same thing, certainly in criminal law, and you get different outcomes. So it depends on a particular legal notable. But I find it kind of interesting now that the Republicans point to the courts as some sort of objective standard when it changes. And in fact, interestingly, we had some Supreme Court justices that said, oh, no, we would never change Roe versus Wade. That's precedent upon precedent. Then, of course, the first thing they did was change it. So it is interesting how things have changed. But anyway, I move on. I do want to ask this, because I always ask this. How many of you believe in climate change, that climate change is happening? You raise your hand if you can. Yeah. And I thought so, and I appreciate that, because I think that's the first time we've ever had that here. Last time, there was a guy that I thought that sat right in front where you do, sir, and he did not. And he raised his hand, and he defended why he didn't believe it, which is fine, which is good. You know, I appreciate that, but I think we've come a long way. I think we have to recognize that. The other thing I would recognize is I do think that what is happening, this climate change, is material. I think that investors want to know. However, I do have some concerns, though, and I am going to turn to you right now, Mr. Schultz, because I do have some concerns. When you said you've planted thousands of plants with your own hands, so have I. I worked in a nursery growing up. I lived on a chicken farm, worked in a nursery. We went from liners to 1 gallons, 1 gallons to 5, 5 gallons to 15s, 15s to 24-inch boxes, and 30-inch boxes and 36-inch boxes. And I did that for years, and my parents certainly believed in child labor. I started working when I was about 10 and enjoyed it, but that's a different thing. I worked with my father. But how does this impact you? I mean, you have a very compelling story. You have a family farm. You seem like to be a very decent guy. How is this impacting you? Because it doesn't seem like the public has invested in your firm. I mean, you're always doing some of this disclosure because of Welch, because of the jam. Even my kids want to know that it's a good product. We use it. How is it affecting you? I didn't get that here.
Yeah, and that's, I think, part of the reason for the hearing today is that, you know, there might need to be some clarity as to what that might look like on the Scope 3 component, because it's a little bit maybe not clear at this point in time. And you can read it so that it would impact all the supply components into that chain, which it looks like would be the American farmer in this situation as well.
So I agree with that. I mean, I do think that there should be some clarity. I'm sympathetic to that, and I think that there should be, Professor, again, and I'm very much in favor of the rule, but I'm sympathetic to that perspective. Could you comment on that?
Yes, so I think we should not prejudge the role. The SEC has been very actively engaging with stakeholders and market participants, industry associations. Let me just quote a staggering statistic, which I was very surprised by when I looked it up earlier this month. The SEC has taken 372 meetings on the climate disclosure rule in the past 22 months. The chair alone has taken 178 meetings. And so the SEC is very interested in hearing feedback about the rule, calibrating the rule, fine-tuning the rule, and I expect that they're very well aware of concerns by...
I think that my time's almost up, so I just wanted to make that last comment. I do think that this is a very important rule, because I believe in climate change. I thank God that all of you do, too. I think the things have changed. The world has changed, and again, I thank you. Mr. Chair, I yield back, and I do have time.
Gentleman's time is now expired. With that, the gentleman from Ohio, Mr. Davidson, our chairman of the Housing Subcommittee, is recognized for 5 minutes.
Thank you, Chairman. I appreciate the opportunity to wave on to this important role of the Oversight Subcommittee. And when we look at what's going on here, this is one of the more aggressive rulemakings in any of our agencies. And frankly, the Securities and Exchange Commission has been hyper-aggressive compared to most agencies. In fact, this has been the most aggressive rulemaking since Dodd-Frank, and Dodd-Frank was a major piece of legislation that passed by the House, the Senate, was signed into law, and of course it prompted rulemaking to follow the law changes. Here, the only thing that happened is Gary Gensler became the chairman. So as I've said, Gary Gensler highlights two problems. We've got a Gary Gensler problem, and we've got a structural problem with the SEC. I would love to restructure the SEC, which would effectively eliminate the chairmanship. We already have the world's best capital markets, and that's shown by the amount of invested capital in them. They function pretty well. The only thing we could really do is mess them up. And Gary has given it a really serious effort at messing them up. This is an example of overreach. It's been cited, but the West Virginia versus EPA, they don't have the legal authority. And so, Mr. Crain, I think when you talk about major questions, this would be a major question, would it not? Why would it be such a major question?
I think that's exactly the right framing. The SEC has a very clear set of legal authorities to require, in this case, disclosure of material information for the protection of investors, efficient markets, and capital formation. This rule doesn't meet those goals. I think it's very clear, and so that brings them instead into the major question which you alluded to, which is outside of their expertise or statutory authority, and therefore calls into question the underlying legal authority to promulgate this rule.
Yeah, thank you. And you think about the implications. We've talked about the cost. The cost to the economy is enormous. I talked with a small business in my district just outside of Cincinnati, Ohio, and he said for one of his contracts, he has a little over $1 million with a publicly traded company. They've done the review, and if they had to comply with the Scope 3 cost, it would cost him about $37,000, so 3.7% increase in the cost of the contract. And, you know, if you could perfectly pass that on, that's 3.7% inflation on whatever that is. But as our ag folks have said, not everyone is a price setter. Lots of small businesses in particular are price takers. So when you look at the pressure that a lot of small businesses are under, what you see is consolidation. The big businesses get bigger, the small businesses go out of business or offshore, and this is part of what's crippled our manufacturing economy. And so thanks to NAM for highlighting some of those really important problems. But Mr. Cunningham, can you please explain how Biden versus Nebraska could impact the SEC's argument in favor of the climate disclosure rule, even if Scope 3 were stripped from the final rule?
Thank you. Yes, I think the West Virginia against EPA and the Biden against Nebraska cases, as well as a third case involving OSHA and vaccinations, all three of those opinions indicate that the Supreme Court is going to be careful not to allow administrative agencies to exceed their grant of congressional authority. That's the major questions doctrine. And I think one additional point about this rulemaking, at least in those three areas, the agency was acting in their lane, even though they exceeded their authority. But here, the SEC is moving into a different lane. So it's sort of, I don't know, major questions 3-0.
Right. So thank you for the clarification on that. And, you know, for these reasons, I mean, I think Gary Gensler is the wrong person to be leading the Securities and Exchange Commission, but I think we have the wrong structure. So when you look at some of our agencies, you see this ping pong that goes on, and it has a big impact down through our market because one party gets their person in charge, and they decide, yeah, we're going to ram through this thing, and it's done with power instead of persuasion. And I'd like to see a 3-3 structure to the commission because then, you know, the 80-20, 70-30 issues, they're going to figure it out. And the things that get political because, you know, this is a topic that's going to get political, it comes to this body. There is a body in our country that's supposed to decide these 50-50 issues, and right now it's about a 50-50 power sharing arrangement here in this body. We're supposed to have those arguments, but we're supposed to have them here in Congress, not with unelected, very unaccountable bureaucrats, and Gary Gensler couldn't highlight that problem much more effectively. I hope we do something about it, and I yield back.
Gentleman's time has nearly expired. With that, gentleman from Illinois, Mr. Kasten, is recognized for 5 minutes.
Thank you, Mr. Chairman. As is so often in this line of work, I find myself playing the role of having to remind everybody that we all over here have the ability to negotiate the laws of the United States. We do not have the ability to negotiate the laws of physics or the laws of economics. The IPCC has been telling us for a long time that we have to stay under 1.5 degrees of warming. That's physics. Last year, we hit 1.48. We are going to overshoot. There's irreversible damage that is coming. According to NOAA, just in the United States, climate-related weather disasters from 2018 to 2022 cost us over $617 billion. That's a little over $120 billion a year. That number is both huge and increasing. Last year, the U.S. climate-related weather disasters cost us $176 billion. Those are the insured losses. Actual losses are worse for those who aren't insured. 2020 CFTC report under the Trump administration said, and I quote, "Climate change poses a major risk to the stability of the U.S. financial system, and regulators and financial institutions need reliable, consistent, and comparable data and projections for climate risks, exposure, sensitivity, vulnerability, adaptation, and resilience." In the last year, we've seen major insurers, State Farm, Allstate, and others, pull out of Florida, pull out of California, pull out of Louisiana. Those risks are not going away. They're simply being punted onto lenders, property owners, including but not limited to farmers, I would add. Given all of this data, is there any of you, the four of you there, who disagree that climate change is creating significant financial risks to our economy and to the companies that participate in our economy? Do any of you disagree with that sentence? Okay, the record will show that we're all in agreement. That's terrific. Mr. Crain, moving to you. When you invest as an individual, do you review the risks that a company is disclosed that they're exposed to before you make your investment decisions?
I'll confess I'm more of a mutual fund investor myself, so I'm not looking at individual stocks all that
Fair
often.
enough. You and me both. Would you advise someone to consider the risks before they make an investment? Put it that way.
Certainly, an investor making these types of decisions would need to understand the material risk.
And if you were considering an investment in a company and you said, boy, I've identified a real significant risk here, can you share it with me? And they said, no, that's not material, go pound sand. Would you invest in that company?
Would have to see the individual facts, but it probably wouldn't be the most productive interaction.
So I share that because when we have hundreds of billions of dollars a year of loss in the system, there's a lot of companies who are saying, I don't want to disclose these risks because I can't attract capital if you do. And my colleagues across the aisle are saying, you know what, that's not material, go pound sand. Understand the motivations here. Mr. Georgiev, Supreme Court in Basic versus Levinson said that information is material, quote, if there is a substantial likelihood that a reasonable shareholder would consider it important. Going back to my question with Mr. Crain, is there any debate that a reasonable investor would view these hundreds of millions of dollars of disruption a year as materially significant and important?
If the investor is reasonable, then they should view these sums as materially important.
Okay. Mr. Chair, I'd like unanimous consent to introduce into the record a 2022 survey by Environmental Resources Management.
Without objection, sorry.
This survey found that institutional investors today are spending $1.4 million annually to collect, analyze, and report climate data to inform their investment decisions. It also found that the average corporation is spending about $500,000 a year, about a third as much money, to voluntarily disclose that data. So in other words, and I think, Mr. Georgiev, I think you had mentioned this in your testimony, this is not a question about whether or not there are costs to disclose this data. Of course it takes time to go and get data. This is a question about who is responsible. So Mr. Georgiev, is it the responsibility of companies to provide information to investors under our accounting rules, or is it the obligation of investors to spend their money to go and discover what risks public companies are exposed to?
So public companies have voluntarily opted into the public company disclosure regime. They derive a benefit, access to highly liquid, large, and efficient capital markets. And in return for that, they have to provide information. That is the basic bargain that has been in place since the 1930s. And so it is very much, if they want to derive the benefits, then companies have the obligation to provide that information.
But are these voluntary climate disclosure regimes consistent? Do all companies provide the same data? Are they all obligated?
No, they're not, and they're also much more difficult to enforce.
Thank you, and I'm out of time, but this hearing is really about whether we are going to protect investors' rights to access information or protect companies' rights to withhold information from investors.
With that, the gentleman from Nevada, Mr. Horsford, is recognized for 5 minutes.
Thank you to the chairman and ranking member for the hearing today. But here we go again. Republicans are so focused on their outrageous culture wars that they're not going to spend our time today talking about the issues that are imperative to the financial sector. Instead, we've convened so that my colleagues can continue to bash what is really a customer-driven initiative. I think that amidst this renewed push, it is worth pointing out that the new products that my colleagues are so quick to deride only exist because there is a market for them. And I thought that the other side was for free markets. Why would we deny wide swaths of investors the information they care about when they are making investment decisions, especially when this information already exists in many instances? I'm really tired of spending our time obsessing over manufactured culture wars instead of doing the work that the American people sent us here to do. Our focus could be focused on access to capital for small businesses, for example, bolstering financial literacy efforts to build a more inclusive financial sector, or, as I've suggested previously, addressing the ever-skyrocketing cost of housing. During our last spat of anti-ESG hearings, we learned just how detrimental it can be if we blind ourselves to the very real risks associated with a company's mismanagement of their local environment. So I'm baffled to have to say this, but I believe that our nation's investors and other financial services professionals know best how to manage their risk. They are in the business of managing risk in all of its forms, and in any risk that these professionals deem to be material, that should be included within the decision-making process of their purview. I'm a firm believer that a better informed investor is never a bad thing, and it is clear to me that the SEC has the authority to prescribe these highly sought-after disclosures. Mr. Djordjev, as you may know, the majority of investors have made clear that they want companies to disclose climate-related information. We've even seen companies begin to disclose this information voluntarily. So then could you describe why that may be the case and what benefits companies may receive by allowing investors to consider this information in their investment decisions?
So voluntary disclosure serves an important role. It allows companies to distinguish themselves from their competitors because, as I said a while ago, investment decisions are by their very nature comparative. And so companies are always looking for a way to stand out. The problem with voluntary disclosure, though, and that's why we need mandatory disclosure, is that when there is negative information, when there are problematic facts, when there are risks, companies, because they're looking to attract capital, are reluctant to provide and disclose the negative information. So they end up providing the positive information without providing the negative information. That's why we need mandatory disclosure, a baseline, a total mix of information that actually informs investor decision-making. And there's an advantage there, both for companies, as you suggest, as well as for investors and for the economy.
So given all the attention given to the Scope 1, 2, and 3 emissions disclosures, I worry that my colleagues have lost sight of the variety of quantitative and qualitative information regarding climate risks that investors would be given access to. Under the SEC rule, these companies would need to not only provide descriptions of their climate-related risk, but critically, they would also need to outline relevant risk management processes. How a company manages their perceived risk is not only crucial for an investor's decision-making, but it is simply good corporate governance to have these processes in place. Let's not forget that a key aspect of the SEC rule is the impact of climate-related events, which occurred at an alarming rate last year and can range from hailstorms to hurricanes. Finally, let me just close by stating that in Nevada, the very real threat of climate change is causing us to quickly confront the increase in these events, namely, for Nevada, a water crisis. We've endured over 2 decades of a drought in Las Vegas, and it would be difficult to believe that that wouldn't be a significant material risk to a certain company's profitability. Mr. Djordjev, would you please speak to the importance for a company to be aware of its local water supply challenges and how this information may be helpful for investors when making decisions?
Yes, so water is a crucial resource, it's a critical resource, and it's a scarce resource. And so it is very important for companies to be aware of supply chain challenges, and this is where water scarcity comes in.
Thank you very much. I yield back.
Gentleman's time has expired. With that, the ranking member, Mr. Green from Texas, is recognized for 5 minutes.
Thank you again, Mr. Chairman. I greatly appreciate all that has been said today. And it appears, Mr. Chairman, that we have to identify our legitimate real farmers' bona fides. So I'm proud to tell you that I know what well water tastes like. I know what G and haw sound like. I know what chitlins taste like. I know what a smokehouse smells like. I know what living on a farm where you have no running water as we know it today is like. I grew up on a farm in my early childhood, and I would have you know that I have great appreciation for Mr. Schultz and what he's having to contend with. And to this end, I have a statement dated September 12, 2023. It's from Reuters, and Mr. Gensler was appearing before Congress, and here's what Mr. Gensler said. It is not the Commission's intent to have farmers or ranchers in Montana or any other state report on goods they sell to publicly traded companies. SEC Chair Gary Gensler said in response to questions from Democratic Senator Tester of Montana. So I want you to know that this is still in its infancy, it's metamorphosing, and it has not been finalized. So there's still much to be said, much to be done, and you have quite a few advocates who would not want to see Walmart pass on its cost to you. I think that this is something that you can be assured people are going to work hard to prevent. Moving on to my next topic rather quickly, but while I'm doing that, Mr. Georgiev, would you comment on my comments, please?
Yeah, so I think your comments are very apt. I think it's important to underscore the fact that what the SEC is doing here is providing, making sure that companies provide investors with relevant information rather than seeking to regulate climate change. And so this benefits all sorts of investors, investors who are agnostic about the effects of climate change, as well as investors who are very concerned about the effects of climate change. Because if investors who are agnostic, if they're contrarian and want to invest only in companies that don't believe in climate change, they will get that information through the SEC disclosure rule. So it helps all sorts of investors regardless of their beliefs. And that is the beauty of this rule, and that is why the SEC is on solid footing in promulgating this rule.
Thank you very much. Moving on to industry experts giving some guidance. This is not novel. When the oil and gas disclosures were codified, industry experts were used. So this is something that we've done before, and there's no reason why we can't do it again. Again, Mr. Georgiev, would you comment on my comments?
That is absolutely right. The SEC is a disclosure agency, and it, in all cases, has relied on the expertise of technical bodies to come up with the right disclosure requirements. So what it is doing here with the TCFD is not at all unprecedented. We had a similar process with the oil and gas disclosure rules, first adopted in the 1970s, revised in 2009, as you point out. We've had the same process in the context of executive compensation, very complex matters of asset-backed securities, and so on and so forth. So the technical assistance that the SEC is getting from bodies, which, by the way, include participation by U.S. government officials and supervision by them, is not at all unprecedented.
Finally, it has been said that on one hand, this should be left to the EPA. But then on the other hand, the SEC already has the authority to do it. So why would we leave to the EPA what the SEC has the authority to do? Would you comment on my comments, please, Mr. Georgiev?
Yeah, absolutely. So just because an issue involves climate change, it doesn't mean that only the EPA and NOAA can touch it. All agencies of the federal government have to make allowances for climate change. The Department of Defense, for example, is making allowances for climate change. And so it is not, the EPA is doing one sort of, it has one particular remit and is doing one sort of regulation. The SEC is doing information regulation for a very specific purpose to benefit investors.
Thank you, sir. I close with, I also know what a hen house egg tastes like. I yield back.
Gentleman yields back. And I know that there's a number of folks that have grown up on a farm. I believe Ms. Garcia was on a ranch, and a number of our members. And so I'm glad to hear that this is taking some root. You read a comment from Mr. Gensler. It may be the intent, but I'm afraid it may not be the application, and that's part of the reason for this hearing today. Recognizing myself here, I wish Mr. Vargas was still here. He was talking about somehow miraculously Republicans have started looking at the courts favorably. One, appointments matter. Two, what those appointments do and how they do it matters. When we see an activist expansionist court versus a constructionalist court, that's very different, and we clearly are seeing that right now. He also asked Mr. Schultz, my constituent, really, how are you affected? You know, I used to represent Fremont, Michigan, which is home to Gerber Baby Food, owned by an internationally publicly traded company that directly contracts with family farms in and around the area. And these family farms are struggling to figure out how they make sure that they can track their organic versus non-organic, much less all of the inputs. So Mr. Schultz might be dealing with a few more middlemen, a co-op, for example, in between. But we've got examples of these growers going directly into a publicly traded company who absolutely are going to get scooped up into this definition. Absolutely. There's no way of avoiding it at this point. So, Mr. Cunningham, I want to go to you. Professor Georgiev put forward two things in his written testimony. He said, one, the intensity of demand doesn't matter for those investors. Interestingly enough, and most recently it was Mr. Kasten who noted this, investors are demanding this information. That was one point, because I'm not sure that investors are quite demanding it. But two, we have dueling lawyer and professors here on this. So Mr. Georgiev's or Professor Georgiev's second point was, nor does it matter if they are interested parties, if the interested parties are actually investors. I believe he notes them as non-investor constituencies. How novel is this in legal theory? Because has the SEC ever given weight to a non-investor constituency before in its rulemaking?
The congressional authority that the SEC exercises is investor protection. That's it. And so everything it does has to connect back to that. And in this proposal, they went to great lengths to talk about investor demand, which is a novel concept, as a way to support invoking its authority under investor protection. But yet, the investor demand that it attempted to measure was just one segment of the universe, and it paid no attention to the 160 million individual investors who really need the SEC's protection.
Yeah. Okay. And very quickly, in your opinion, do you think these courts are these constructionalist courts are actually going to overturn this activism?
We've identified several deficiencies in the proposal, and if it was released or finalized as proposed, I think it would be very seriously in jeopardy.
Okay, I'm going to turn to Mr. Schultz here to close. There was a court case, a U.S. court case, American Farm Bureau Federation versus the EPA. It held that public disclosure of farmers' personal information is, quote, substantial and, quote, clearly unwarranted invasion of privacy. And I think you touched on this. This isn't just where you work, it's where you raise your family on this. And I think it's widely acknowledged that there's privacy concerns disclosing your operations and those details to the SEC if this climate rule were to be finalized as it is. Have you been told anything that would give you assurance that somehow that data is going to be protected? I might note that we just had a recent breach of the SEC's data.
Yeah, I don't know if I can speak, a lot on that subject, though I can tell you that if we start pitting data from smaller companies into the marketplace, you're going to drive consolidation down, and I don't think that's necessarily what the intent of this rule is, but it could definitely have that impact.
Sadly, Mr. Schultz, I've been around here long enough as a staffer and as an elected member to know that oftentimes it's those unintended consequences that are what have the biggest bite and the impact and are frankly the hardest to remove from that. I want to say thank you to you for that. You have noted how your family works towards conservation and stewardship, and maybe we can end on that.
Thank you, Chairman.
So, well, with that, I also have a article that I would like to put into the record, rejection in this Wall Street Journal article entitled "The Latest Dirty Word in Corporate America, ESG," and without objection. So with that, I will say again, thank you to our witnesses. Deeply appreciate your time, your effort in getting here. The members will note that if they have additional questions, they can get those questions to me, and we will be bringing that to our panel. And if you would please answer those expediently, that would be helpful. And without any objections, we are adjourned. Thank you.